Good Monday morning, afternoon, evening, depending upon where you are in the city. Welcome to From the Halls of Justice. Today we have an outstanding guest, a rising star attorney, a superstar in her own right, and her clients love her and adore her. I am honored to have with us today on Channel 36, live in West Hollywood, Alexandra Rachel Lavinsky.
Thank you.
Esquire.
Thank you.
Thank you so much for being on the show.
Thank you for having me.
There are so many wonderful things that we're going to discuss, and our audience is going to really enjoy this interview. You are such an exciting person, and you've done so many outstanding things. Let's just start with, where did you grow up?
I was born in Philadelphia, Pennsylvania, and then my family moved to California when I began ninth grade, and I attended high school in Palos Verdes.
Wow.
And then I went on to UC Santa Barbara.
Oh my goodness. So, do you have any brothers or sisters?
I do. I am one of 4 children.
Okay.
I have 2 older brothers, both of whom are also attorneys. And I have a younger sister who is an urban planner, and one of my brothers is married also to an attorney, and she happens to be the mayor in Ross County in San Francisco.
Oh my goodness.
Yes, and the past president of the Marin County Bar Association.
Oh my God. So a family of attorneys and mayors.
Yes.
Oh my God. Impressive. Very impressive.
Yes, and my grandfather was a judge.
Oh my God.
Yes. And I have an uncle who is also a lawyer in the Los Angeles community.
Oh, this is an awesome family. Your mother must be so proud.
She is.
Now, a few things that I know about you is that I know that you practice civil law.
Yes.
And so tell me a little bit about that.
I did. My background is in insurance defense, and I worked at a firm prior to starting in family law. And working in civil law really helped me to grow what I call my litigation legs by giving me deposition experience and trial experience and one-on-one experience with clients that many times in small firms, young lawyers don't have the experience of. And from that large firm experience, I then was able to transition into a smaller firm experience and focus on family law where I felt I could make a difference.
So you did a lot of civil, you were with a large firm, and then what made you transition into family law?
I really had an interest in reaching out and helping people. And I had worked in family law while I was in law school. But I felt that I could be a much better lawyer if I had some civil law experience. And with all of the mentors in my family, I heeded the advice. But my ability to reach people and to make change in people's lives is something that I could accomplish in family law that differentiates family law from many other areas of the law.
I agree with you. I love family law. I'm going to ask you a few questions that you're going to be able to help me bring to the audience some education about family law and about the courts. If you would be so kind, how long would it be before I could get, or anyone could get, a divorce in the state of California?
In the state of California, there's what's called a waiting period, a time for reflection, and that is a 6-month period. So from the time that a party is served with divorce papers until the time they are officially divorced is at a minimum 6 months.
Okay, so if I just moved here from out of town, and let's say if I came from Washington or Texas, and I figured, you know what, I'm here and my husband and I are not getting along, I want a divorce. Do I have to wait?
In the state of California, in order to file for divorce, one must be a resident of the County of Los Angeles for 3 months and the state of California for 6 months. However, if one files for legal separation, different requirements apply that enable somebody to file without having met those residency requirements. As well, marriages that involve same-sex unions, people are able to file for divorce in same-sex unions in California without meeting the residency requirements. And that's because certain other states in the United States do not allow or acknowledge same-sex marriage, and so that would make it impossible to divorce in those states. So California offers that to non-residents.
And how many states would you say do that?
I am unsure how many states do that.
Okay. I mean, I know that, would you say New York, California, and...
I believe any state where same-sex marriage is accepted, that is a state that would allow a divorce to proceed.
Now, if they're filing for divorce in California, do they have to have a lawyer represent them in California?
In the state of California, one can represent themselves in a divorce proceeding. In fact, many people believe that you automatically have a right to an attorney, which you do not have in family law. The only time in family law that one would have the right to an attorney is if they are facing what is called a contempt proceeding. And that is because a contempt proceeding, one faces jail time, and so it's called a quasi-criminal proceeding. And so that is why they have the right to an attorney, just like a criminal proceeding. But one can represent themselves in family law. As well, our city provides wonderful self-help avenues for people who cannot afford legal representation. There are centers such as the Legal Aid Foundation and Harriet Buhey Center and Levitt and Quinn and the self-help centers that are in most of the courthouses are really there to try and help people get through this system. And if you live in Los Angeles, there's also a self-help website, and that is very helpful, where you can find all of the forms necessary and many, many instructions for how to get through the legal process.
So how do I know where to file a divorce in California?
When one goes to the website, the Superior Court website of where they live, for example, in Los Angeles County, when one goes to the Superior Court, the Los Angeles Superior Court website, then you can put in your zip code. And from your zip code, it will tell you where you can file. But you can file in the courthouses within the county where you live.
Wow. Now, after you file for a divorce, this is great. How do you know where all the assets and debts are?
This is a very, very difficult question, and it's a very difficult topic for people that either have not been in touch with one another or do not trust each other, which often happens through the divorce process. The state of California requires that both parties disclose their assets. There are 2 necessary forms that one can get from the website that I referred to earlier today, but it is called, one form is the Schedule of Assets and Debts, and one is an income and expense declaration. And it is from there that a party can start to look at what the other party says are their assets, and either they determine, yes, this person is telling the truth, or no, they are not. And if you determine no, I don't believe they are telling the truth, then you have two avenues. Number one is to do what's called formal discovery, where you ask the other side to produce documents and to answer questions either in a deposition or in written form. And the third way to find out is by issuing or having an attorney issue subpoenas to banks and to different institutions, employers, to really determine what the financial status is of the community estate.
Wow. Now that sounds like it's a lot of work.
It is a lot of work, and it also can take a lot of money. And so for people who don't have a lot of money, who just want to get through the process and can only do what they can do, if they enter into a settlement agreement, and at the end of the day, most divorces end, or most partnerships end in some form of a settlement agreement that the judge will sign off on. If one party or the other finds out after the settlement agreement is entered by the court that one of the parties has been lying, there are remedies for that. It doesn't always mean that the settlement is going to be set aside, but you may get either half of the asset that's been undisclosed or 100% of it or more.
Wow. Oh my goodness. Okay, it sounds like we need to talk about evidence. Let's see. How would, or anybody absolutely, would be able to get access, well, you talked about the subpoenas, to financial documents when you need to know what the assets and the debts are?
And this is one of the wonderful things about the judges in our system, is they are very well educated and they know the games that people try to play. So as long as the parties use the correct forms, then the judges will respond and give the relief that is necessary. So preliminarily, you ask for the documents and those documents are not produced. Your remedy is to go to court and to tell the judge through the proper filings that the other side is not producing the things to you that you need, and that will result in either financial sanctions or evidentiary sanctions. The other side of this is, in the state of California, everybody has the right to equal legal representation in a family. So if one party has little access to finances because the other party has taken control of the assets, then one can go to court, has a right to go to court, and ask for money so that they can obtain equal representation.
Wow. Now, while this is going on, do you have to appear in court?
Many people ask this question, whether or not they will ever have to appear in court, because many people are afraid to appear in court. Mm-hmm. The first thing that I like to tell people is there is nothing to be afraid of in court. It is much better to have a judge decide rights and ramifications instead of a party just rolling over and being very dissatisfied and angry. But when it comes to custody, this is a very unusual area because parents are the best people to determine what is best for their children. Even a judge, as much as a judge cares about all of the children in Los Angeles County, which they do, they still don't know the ins and outs of these particular children that they never lay eyes on. So if parents can come up with their own parenting plan, that is the best resolution. But yes, it is possible to get through the dissolution process without ever having to appear in court, either because people agree and reach settlements outside of court, and they go to mediation if they can't reach settlements on their own.
I was going to say, now sometimes because they're going through a divorce and because there's so many emotional issues, isn't it difficult for them to reach a settlement?
Well, this is another difficult area because...
And do they have to agree to what the mediator says when they're in settlement?
Unless it is a binding mediation, which most mediations are not, people do not have to agree to what the mediator proposes or what goes on in the mediation. In Los Angeles County, when people file for child custody issues, they will be sent to conciliation court to see a mediator to try and resolve the matters. If they can't, they will see the judge. If parties want to try and mediate a case so that they don't have to go to court or have to hire lawyers, then the parties can go to an outside mediator and see if the mediator can help the parties resolve a case. However, mediation can sometimes be a waste of time if the parties do not know what they're going to the mediator for.
Wow.
So I often tell people that if you can find out through doing the disclosure documents what you say there is and what your partner says there is, then the mediator can be helpful in deciding what can be a good resolution.
Wow. So, and that's very important, the disclosure documents, because if you get two different sets of documents in front of you, who's going to decipher who's telling the truth? I mean, like you said, if there's disclosure and you're saying, one person is saying, well, there's $1 million worth of assets, and someone else is saying, well, actually there's only $100,000 worth of assets, and we've got X amount of debt, and it's hard.
It is very difficult, but one of the things that I think can be done in mediation through society now, because we have computers, is that we can sit in rooms and look at accounts and see what money there is. It used to be that we couldn't do that so easily. So if parties really have a desire to work together, there are ways to facilitate that, and there are people who can be very helpful in doing that. And if parties don't want to be helpful in doing that, then there are sanctions for people who don't obey the discovery laws and the disclosure requirements.
Wow. That's a whole nother show. Let's see. So, they're in court. We're going through disclosure. How is custody decided by the courts?
Custody, as I said, the first thing that happens when a party files for custody, and in the state of California, nothing happens with the court until somebody seeks a court order, and in Los Angeles, that's called a request for order. So somebody files a request for order seeking custody, asking the court, please make this custody order, and the court automatically sends the parties to conciliation court to see if they can resolve it. Once the parties have not resolved it, if they have been unsuccessful in that mediation attempt, then they will go to court. And the court has a number of options that it can use to help it to make its decision if the court feels that it is not in a position to just do so without meeting the child, without having somebody talk to the child. So in Los Angeles County, the court can use a child custody evaluator, which is a process that can either be done through the Los Angeles Superior Court or through a private court evaluation process in what's referred to as Evidence Code 730 custody evaluation.
What is a 730?
A 730 custody evaluation is when a psychiatrist usually evaluates both parties and any collateral sources, whether it's teachers, girlfriends, boyfriends, psychiatrists, psychologists, any other third parties who may have relevant information to help this psychiatrist determine what is the best parenting plan for this family. And the court actually has its own people to do that if the parties cannot afford an outside 730 evaluation.
How long does a 730 evaluation normally take?
If the evaluation is through a private evaluator, it can take approximately 3 months. If the evaluation is through the Superior Court, because of the calendar of the evaluators, it can be prompt, but it is dependent on the calendar. So usually it can be done within a month. But that assumes that the evaluator has time to do all of the things that are necessary. But the judge will order the evaluation to be completed by a certain time, and usually that is complied with by the court staff.
Wow. Now, what can the court do to ensure the safety of children during visitation?
Many times during either the evaluation process or if there's allegations of domestic violence or whatever it is, there are circumstances that the court feels or the parties feel that one parent is not safely alone with the child, or I should say the child or children are not safely alone with a parent.
Okay.
So what can happen is the court can order a monitor, or the parties can agree to have a monitor, either a family member or a paid monitor. And with a monitor, a party is still enabled to have their visitation without the interruption of the concern of a parent. Now, of course, parents don't like their visitation to be monitored all of the time, but the courts look at what is in the best interest of the children. And when a party is choosing their own personal feelings over their child's desire to be with that parent, the court can look upon that in determining whether or not this party is in a position to really make decisions that are best for the child. We always have to be making decisions that are best for the child, even when it hurts our own feelings as parents.
Okay. Is there a certain amount of time that the monitored visitation must be in place? Will it ever expire?
Yes. Monitored visitation cannot go on indefinitely. There must be things in place for the court to review the monitored situation. There are times where the court may feel a party always has to be monitored, and so maybe I want to revise my answer. For example, if a party has attempted to kidnap a child or has taken a child, it's very likely that that party is going to have a monitor for the duration of the child's childhood until that child is no longer a child and is 18.
Wow. Now, are there parenting classes for co-parenting?
There are wonderful co-parenting classes. There are free co-parenting classes. If people go on the Los Angeles Superior Court website, there are free parenting classes. The court will order parties to do parenting classes, and people can Google in your area, for example, Los Angeles free parenting classes. And there are so many free parenting resources everywhere. It really is amazing.
You are just a wealth of information.
Thank you.
Let's see. Now, spousal support. When can people waive their right to spousal support?
So spousal, and I'm going to combine the two topics.
Okay.
Spousal support and child support. Spousal support and child support, usually in the state of California, are determined by a computer calculation called the DISO-master. And really what the court cares about are the incomes of both parties and the timeshare, how much the parties are spending with the child. That is it, not the expenses of the parties to determine whether they can afford support, because in the state of California, one's first duty is to support your child and then your spouse. In the state of California, one cannot waive a child's right to child support because child support belongs to the state of California. Parties can decide they are not going to ask each other for support or collect child support, but they cannot waive it. Spousal support, on the other hand, parties have a right to waive spousal support. In order to waive spousal support in a settlement agreement, it has to have magic language which says that it is being waived forever and certain other requirements have to be met. But yes, spousal support can be waived. Child support cannot. Spousal support is also tax deductible to the person paying support. And child support is not. There are no tax consequences for the payment of child support.
That's amazing. That's another show too. It's like, well, why not? So, and this is amazing because we are in an era of uncontested divorces.
Yes.
And so when people are doing their own divorces and let's just say, for instance, you have a husband and wife and they're both equally financially sound, and they decide that, I don't want you to pay child support. I don't want to pay child support, and I don't want you to pay child support. I just want you to go away and leave me alone. And I'm going to take care of the kid, and that's it. And that way, if you don't pay child support, then I don't have to let you see the child. Can they do that?
No.
Okay.
In the state of California, payment of child support has nothing to do with parental rights.
Mm.
And if one is negligent in paying their child support, the parent receiving the child support should not withhold the child for that reason, because they can really suffer some consequences. The state of California believes both parties have the right to share bonded and close relationships with their children.
Well, that's a good thing. Well, and one of the other things that we want to know, the audience would like to know, can they modify a custody agreement?
Yes. Custody agreements are always modifiable until the children are no longer minorities.
And the audience would like to know another, what about a settlement agreement? Can a settlement agreement be modified?
A settlement agreement can only be modified under very specific reasons, such as fraud, mistake. The court and the state of California has an interest in finality of settlements, and therefore usually there are other remedies. For example, if there's an asset that hasn't been disclosed, then there is a remedy for that, but it's unlikely the court is going to just set aside a settlement agreement.
So we're back to disclosure and evidence and discovery.
Yes.
Wow.
Yes.
You have given us a wealth of information. You rock.
Thank you. Thank you, Wanda. Thank you for having me.
You know what? I mean, this is just totally amazing. And I don't even want to tell the audience how much this type of information, how valuable it is, because a lot of people will make you come in and pay for this type of information.
That's
so
true.
I thank you for being on the show.
Thank you very much.
And one other thing that they don't know about you is that you really are a caring person, and in your office you do give consultations and you don't charge a fee for them. So
Yes.
you are a wonderful person, and I thank you for this community time that
Thank
you've
you.
taken to share with us today.
Absolutely, and I believe that the most important thing is for a person to get along well with their attorney and trust their attorney.
That's also another show. You got to tell us how to pick a good attorney.
Yeah. Thank you, Wanda.
Well, that's our show this week on From the Halls of Justice, and I hope you tune in again next week and join us again, where we're going to talk more about the Superior Courts and tell you more information about the law in California. Join us again next week.